Hey, everybody, this is Kathy. Sorry for the no notice for this morning's live, whether you're listening live or if you're going to be joining us on read later on, either on our podcast or here on our YouTube channel. I felt that it was important to get on here live this morning and to address a matter that there seems to be a lot of misconception about. There are rumors that are going around. There are un there are false representations being made, in my opinion only. This is again something that I give pursuant to the First Amendment, as I do always, my opinion, commentary, speculation. And it has to do with yesterday's first court order that has appeared on the public docket, first filing of all, in Idaho versus Kohberger. This was the state of Idaho's amended motion for reconsideration of documents being released under seal. Judge Stephen J. Hippler signed an order yesterday sealing that amended motion. So we don't know what the state of Idaho's issue is concerning the third court order relative to the release of documents to the public, because the motion is under seal. There has been so much confusion regarding what happened on December 30th as it relates to multiple documents that were published with no redactions, that were from the end of March 2025. Sealed to the public. It's a year later in some cases. If you recall, December 30th, 2025, finally, documents started to be published on the Idaho versus Kohberger docket regarding the December 18th, 2025 Judge Stephen J. Hippler order that found that dozens of documents were to be released on the public docket with zero redactions. No redactions whatsoever. That is what the court ordered on December 18th, 2025. And all of the documents that were released on December 30th and suddenly pulled were part of that section of the court order. That said, Judge Hippler could see no further reason to keep these documents unsealed to the public. And yet, as of yesterday, as of today, we're still hearing in the community people saying, oh, someone's in trouble, someone went rogue, somehow accessed the court docket in Ada County, published all of these documents without authorization. They're going to get fired. These documents were leaked. Wrong, 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 wrong. All it takes is a look. You have to look at two documents. What may be the confusion is that the December 18th order, if you go to page number 1, and I've listed them, if you don't have access to the court docket immediately, just go to our community page. There's a 2-part post that's there this morning. I've also put out some content, both on the podcast and here on YouTube, trying to debunk these rumors as to exactly what the December 18th order says. But if you want to go and just check out live on our community page, look at the last 2 items. The last item that I posted was Judge Stephen J. Hippler's order unsealing, redacting, and or maintaining sealed status of documents 88 to 179. And it begins by saying, on October 16th, the court issued an order seeking the parties' position regarding the unsealing of the third set of documents identified therein as number 88 to 179. Then there's a footnote referring you to the October 16th order. He says here, the court has reviewed the parties' respective responses and rules as follows. Okay, so this is the judge who has jurisdiction over this matter. It's Judge Hippler and Judge Hippler only, not anyone else. He has ruled as follows. If you go to Section A, documents to unseal, and there's two paragraphs here. Number one, the first paragraph, with regard to the following documents, the court received no objections by either party to their unsealing, and the court finds no further justification to warrant their continued sealed status. And there's a couple dozen numbers listed here. Unfortunately, he did not publish the titles to these documents. And that's where maybe some of the confusion comes into play. That's why we have to go back to the October 16th order to take these numbers, 88, 89, 93, 97, 101, and so forth, and see what document exactly from the January to March items on the court docket that are under seal that these rulings respond to. Now, the second paragraph, the only difference he says here is that with regard to the following documents, the court received objections by one or both of the parties to their unsealing. However, after considering the objection, the court finds no further justification to warrant their continued sealed status. And then again, there's a series of numbers, 95, 99, 100, 102, 104, and so on. Couple dozen more documents. So this is telling us within these first two paragraphs that Judge Stephen J. Hippler, the sole jurist who has jurisdiction over this case, has made the determination as of December 18th, 2025, 3 weeks ago, that he saw no further justification to keep these documents sealed from the public. Yet, if you were to go onto the court docket today, January 6th, each and every one of these documents are still under seal. Now, what it says here is court finds no further justification under the second paragraph. However, after considering objections, that means that one or both of the parties objected to certain of these documents being published either entirely or being published with no redactions, but the judge overruled those objections, which he has the right to do. So therefore, if looking at these, now what you have to do is you got to take those numbers. And what I've done is I published the first 2 pages of the October 16th third court order regarding potential unsealing of documents that lists the number. And if you go down, it starts with the number 88, state's response to defendant's proposed jury questionnaire. 89, defendant's objection to state's jury questionnaire proposals. 90, exhibits to defendant's third supplemental response to request for discovery. Those are the first 3 documents from March 31st, 2025 that were under seal, that are still under seal as of today. If you go further down to the meat and potatoes, the heart of what I think a lot of the controversy has to do with state's exhibit as it relates to Walthall, to Seat, to Nord. And then if you go on to the next page, exhibits related to Hille, to Gilbertson, to Youngling, to Wilt, to Mychek, and so on. Ayers, and Mowry, if you go to the court order, you're going to see he ordered them to be unsealed without redactions. That's Judge Hippler's December 18th court order. It is still in effect as of today. There has been no amendment. There has been no rescinding. So the fact that those documents are not on the court docket today appears to be what might be the failure to comply with the court's order. So all of this nonsense that people have published things that were under seal, supposed to be under seal, the result of someone going rogue or leaking, completely false. And we have to stop spreading those rumors because it's making it look like people are doing something wrong here and not in compliance with what the court order said. And people getting into trouble, people being reported, complete nonsense and foolishness because the court ordered those documents to be unsealed without redactions. Now, what some people have guessed is maybe they got pulled down because there's sensitive information in them, which I agree with. Social security numbers, fingerprints, handprints, but that's a question that needs to be addressed to Judge Stephen J. Hippler. He's the one who said no redactions. Okay, I'm going to get off my high horse for a minute and say hello to some of you who have joined us with absolutely no notification that we were going live this morning. SRB 9836, good morning to you. Glad that you're listening in. Michelle, You're welcome. Thank you for being here. Thanks so much. Charm Free, good morning to you, member of our channel. I appreciate the support. Down the Rabbit Hole to Hell, another member of our channel. I appreciate your report. Thank you for ironing this out. The rumors are rife. Now people are getting reported. You know who needs to be reported is whoever decided to take those documents down, in my opinion. Because Judge Hippler, jurisdiction over this case, December 18th, that's the only order that remains in effect as of today. As of today. He has never entered a second order saying, oops, okay, maybe these documents shouldn't have been published. And so now they're going to be published without redactions or giving some sort of an explanation as to why they were pulled down without a supplemental order. Basically, his court order has not been complied with for 3 weeks now. And this is the longest period of time that it has taken for the court to make these rulings and for the documents to be released to the public. We've published so much content over the course of the past few months regarding the process by which Judge Stephen J. Hippler announced after Mr. Kohberger pled guilty as he did, July 2nd, 2025. He pled guilty to all 5 of the counts. That day, what that pleading of change of plea hearing did and meant is that the jury trial that was scheduled to happen in August also got canceled. And that's where I believe the public had thought that finally, after more than 2.5 years of a gag order being in effect from day 4 in the case, of document after document, one or both of the sides filing motions to seal. Sometimes filing stipulations where both of them agreed that documents should be withheld from the public, and order after order after order after order entered granting. I have not seen one order since I began covering this case for the podcast where I have looked at every single document on that court docket, beginning with document number 1, the affidavit of probable cause, all the way down to January 5th, yesterday's court order. I've tried to keep it 5 minutes or less, reporting on what has happened in the case. I can't remember one time Judge Marshall, Judge Judge, or Judge Hippler ever denying a motion to seal something. Not once. So we thought here, okay, well, finally, now we're going to be able to see what the evidence beyond a reasonable doubt that Mr. Kohberger was not just the sole defendant responsible for the crimes at 1122 King Road, but he was the only defendant responsible for the crimes at 1122 King Road, meaning that there was no alternative perpetrator, that there was no co-conspirator, no accessory before the fact, no accessory after the fact. It was Mr. Kohberger within that short period of time. Given now what we know, the little bit of information that we have regarding the injuries that those 4 victims who we do our work for to uncover the truth of what happened to them, Kaylee, Madison, Xana, and Ethan, it is the state of Idaho's position that one person did all of that damage in a short period of time. But yet the court is refusing to open this case. I have made on my podcast, I cannot tell you the number of times that if you go in and search it, it's on Spotify, it's populated over here, it's populated over to other platforms as well globally. You're going to see a title. Oh, another document under seal. More discovery, that's evidence under seal. Here we go with another stipulation under seal and talking about the problems that it was causing. Yes, there's no doubt Mr. Kohberger was entitled to a fair trial and there was a tremendous amount of pretrial publicity. But guess what? The sealing of the case from the public didn't stop such things as the Dateline special that came out just a few days before the final pretrial conference, did it? Where there wasn't, as far as I can remember, and this is my opinion only, there wasn't any type of a proclamation that under our form of government, the documents that created this country, that a person is considered not guilty until adjudicated guilty in a court of law, or they plead guilty. Not one. So guess what? The sealing of the case didn't have a great effect on not having negative publicity get out before trial. So Our country was built on the foundation under the First Amendment, freedom of speech, freedom of the press, that the members of the public should be able to talk about something that's going on in our country, like a trial of this magnitude that has garnered global attention. We should be able to have the opportunity to discuss it, but we can't discuss it if all the evidence is under seal. Can we? Oh, Christina, thank you so much. Oh, one of the best channels on YouTube. You are so kind. I'm so thankful that you are a member of our channel. I enjoy your input. I enjoy your feedback. I enjoy everybody's commentary. What do we see here? We see Down the Rabbit Hole saying, you're on fire. Yes, I am. This is getting on your nerves, lack of courtesy given to the procedures in order to give. Well, it is. This is not just today. It would be one thing, Down the Rabbit Hole, if I had not been reporting on this case for 2.5 years, as I have been, where I have seen in real time the motions to seal for, in my opinion, were questionable reasons. But I feel this is just my opinion. We're having a discussion under the First Amendment here. My opinion is no better than anyone else's. My opinion is that case was overly sealed. As tragic as those horrible, horrible events of November 13th, 2022 were, unalivings happen every day, unfortunately, in this country. And sometimes there are multiple unalivings. They're not sealed to the extent this case is. Why was this case sealed so much to the public while it was happening? And now there's this mess of having to go back and deciding, okay, well, we're going to issue an order and you have 2 weeks to come back and tell us which documents that you're responsible state and you are responsible defense, having sealed from the public. You give me your opinions why they should not continue to be sealed, why they should not be unsealed with or without redactions. So he's done that 3 times. We had the first court order that came out for July and June. He said he was going to start at the end of the case. Oh, here's a question rhetorically that I asked. What about the multitude of documents that have been filed under seal up to and including yesterday? When's he going to get to that? When's he going to get the documents that were filed under seal in September of 2025, in November of 2025, in December of 2025, and in January of 2026? If he's working backwards from July through, he's got to go back to December 29, 2022. That's the beginning of the case. 4 documents were filed that day. Affidavit of probable cause, that's the warrant affidavit, 18 pages, signed by Detective Brett Payne, under seal, that said, here's the reasons why we should arrest this man, Judge Marshall. This is why we want an order entered that had so many errors in it. I just went over it 3 years later. I went over it when I started the podcast. I went over it just a couple of weeks ago. And we don't know if were there 1 or 2 cell phones that they were looking at, because the affidavit of probable cause said that they were tracking the 8458 phone and the 8548 phone. We're tracking him in a town that was supposedly in Idaho, which really actually is in Washington, that says that Kaylee and Madison were last seen in 2 locations, 1:30 a.m. on the 13th of November. That affidavit of probable cause will tell you that Madison and Kaylee at 1:30 a.m. were at the Corner Club, and at 1:30 a.m. they were also at the Grub Truck. So many things like that. Thank you so much, Jen75. Oh, it's my pleasure to break it down. It is my pleasure to break down these filings, because the goal of our podcast and the goal of this YouTube channel is to provide our listeners, our followers, our members with tools, if they don't have a formal legal education, to understand, like, what's taking so long with the January, February, and March orders of filings. That's when the in limine briefings happened. And that's when everything's under seal regarding the text messages. No, I don't want to hear what the defense says those text messages say. I don't want to hear what the state says those text messages say. I don't even want to hear what Judge Hippler says that those text messages say. I want to see the actual text messages, what time they were sent, who texted who called who, and I want to be able to see that evidence for myself, because I believe everyone has a right to do under our Constitution: freedom of speech, freedom of the press. There's also IgG DNA evidence under seal in the motions in limine. What else? Suspect vehicle 1, bushy eyebrows identification, the tracking of the phones, all of the most controversial issues in this case are contained in those in limine filings. Maybe that's why it's taking so long with this particular set of documents. So what we like to do is we like to break down when you see the briefings on the in limine filings, that just means that someone filed a motion in limine. A motion is an application or a request for a court order granting whatever that motion says. That's all that is, because they can't call up Judge Hippler and say, Judge Hippler, I would like you to render an order preventing the text messages from coming into the case. No, they have to file a motion. The other side gets to respond. That's the second in the 3 briefings. And then the third is a reply. When you see a reply, hopefully they're going to be unsealed soon. If you see a document that's called a reply to a motion in limine with under seal documents now sealed to the public, recognize that doesn't stand alone. There's going to be a preceding motion, a response, and then the reply. The reply replies to the response. And then Judge Hippler rules. Those are the types of, just tips and tricks that we like to talk about. So when you go onto the docket and you read these documents, that you don't need me or anyone else to formulate your opinion, because every one of the people who follow this channel could have been on that jury, or any jury determining whether a person's life, liberty, or property gets taken away. So that's what we're here for. Oh, Jackie, it's so good to see another member of our channel and another constitutional proponent. That on point, Rican. So glad that you're here today. Thank you so much. Thank you all for being here. Let's celebrate we want to see the phone records. We want to see those phone records, right? All the things that we should have seen at the trial finally. And there's still questions. Is he the correct defendant? Is he not the correct defendant? Was he involved with someone else? Was he not involved with someone else? Were there co-conspirators? Were there alternative perpetrators? Were there accessories? Someone who did something before the crimes happened to assist, someone afterwards, a cleanup might be, an accessory after the fact. Those types of hypotheticals. That's what that trial should have told us. And here we are, ladies and gentlemen. It is now 6 months and a few days since July 2nd, when the trial was canceled. And but for a couple of documents that were released regarding July and June that were under seal, and a couple more that were released April and May, this case is still largely under seal today. When anyone says to you, because I know the people who follow this channel don't follow this channel because they do not believe in what our form of government dictates, that a person is not guilty until adjudicated guilty in a court of law or until they plead guilty, and does not have due process requirements, and that there's not a First Amendment that says that the people need to know what's going on in courts to make sure that judges, that prosecutors, that law enforcement, and that defense attorneys do not abuse the powers that they have. It's the public who has to oversight all of that. And that comes from the Supreme Court interpreting the First Amendment directly. Amy, thanks for being here. Very, very strong supporter here with us today. Christina's saying that this case is so sad. They ruined a person's entire life just to protect the university. Hi, George. So glad that you're here. Mom's thinking, thank you, Kathy, for all you do, not just in this case, but for our rights too. Hey, I've said it before. I'll say it again. Some of the people who are anti-First Amendment, who are anti-14th Amendment due process clause, who do not like what the founders of this country, with the 13 original colonies, demanded. They were the 13 original states. They were not going to sign a constitution that they came up with in Philadelphia. They said, we just went through a multi-year war against England, the best in the world. They didn't have shoes sometimes. They didn't have didn't have food to eat, but they said, hey, give me liberty or give me unalive. I'm not living under a regime. I'm not living under a king. And this Constitution, the way that you're presenting it to us, George Washington, Ben Franklin, Thomas Jefferson, et cetera, is putting us in a position where you could start another another place where we have to deal with kings and queens again, where it's not all people are created equal. That's why you see the Bill of Rights, and that's why you see the First Amendment. It's because of those 13 original colonies. And the people who are anti-United States government, the founding documents of this country, cannot answer me when they come on this channel and say, you're a Kohberger, what about the victims? I say, give me one reason why, if this man pled guilty over 6 months ago, this case is still under seal. Why documents that were ordered to be released to the public on December 18th, 2025, at paragraph A, page 1 of Judge Stephen J. Hippler's order, were released for a few hours and then taken down? Give me an answer. Give me a logical opinion. They can't come up with one. So therefore, my recommendation is, if any of you are ever attacked for standing up for it's our rights too, because my experience has been those people that argue against due process are the first ones that will jump up and down and demand their rights if they're given a parking ticket that they feel was unfair. They'd be the first one demanding their rights, fighting that parking ticket, going to court, challenging what the cop wrote, the parking ticket. You're talking about, we're dealing with the ultimate freedom that someone could say, not just liberty, which is taking you and throwing you in a jail, but your life. That's what the due process clause means. We have got to, I believe we have an obligation as citizens that are interested to speak out. And the way that we do it is by going to people who can affect change. Our representative, your state, your federal representative, write them a letter, call them, ask for a meeting, go to, when they have meetings, when they come out and they meet with you, go and meet with them, do something, sign a petition, tell your friends, tell your relatives, tell everyone what is going on in this case, because this case is setting a precedent. I can already see it in the Utah case where things are under seal. People are going to be citing to this case. Do we really need another case like this? Do we really need, how many more cases can we stand to be under seal to the extent that this case was and where it's not? And at this pace, how long is it going to take Judge Hippler to not just go to the beginning of the case, but then circle back to how many orders are going to be under sealed in 2 years from now at this pace when he gets to the beginning of the case? How long is it going to take? 3 years before this case is unsealed? I don't know. What do you think? Yes, I am. Yes, I am. I guilty as charged, J-Rod. I am very much a pro-United States Constitution, just like you. And again, people have criticized J-Rod unfairly. He is a proponent of the United States Constitution, of which Puerto Rico is part of the United States. People need to go back to their 8th grade geography books. It will tell you that the Philippines, Guam, Puerto Rico, et cetera, are they're territories of the U.S. So continue to speak out, please. So Down the Rabbit Hole is saying, Kathy, this is happening in other cases like the Innocence Project covered. Then this is an example of why corruption had to be out. Well, there are, I agree with you, Down the Rabbit Hole. I agree with you. The difference between this case and a lot of the other cases, and I would even say the Allen case, which is right now on appeal that we are covering. I think Idaho versus Kohberger exceeds all of the cases because of the unprecedented attention that it got globally, and the books and the documentaries and the specials that were put out while this matter was on pretrial. It was excessive. It was to the point where, okay, May 15th, now we're at the final pretrial conference. I'm doing my final preparations to close out my coverage of this case because I fully expected that by November, Judge Hippler put together a very aggressive order, and he denied the motion to continue the trial, didn't he? So by November, I'm thinking, okay, Kohberger is going to be done. What other cases? I actually put out a poll. What other cases would you like us to cover? Because this case has taken up so much of my time over the past few years, not just because I was important to me to cover it in the name of the victims here, but because I felt that injustices were being done to our First Amendment, and we just couldn't tolerate it. And then all of a sudden, out of nowhere, I know exactly where I was, June 30th, we were doing a live here. We were preparing for the final pretrial conference when all of a sudden people were saying, oh, wait a second. I think it was News Nation is reporting that Mr. Kohberger signed a plea deal. I said, what? Where'd that come from? They were actively preparing for not just trial, but for Dyer. When Dyer was happening in July, they were going to send out all of these secretive surveys that were going to go out to thousands of people to start the Dyer process. I mean, they were weeks away from that. And then a plea deal? I don't know. Down the rabbit hole saying KG and MM being at the corner club and also at the grub truck at 1:30 a.m. is like they've just made it all up. They went along. The phones should show a timeline. Where is the phone data on each? Well, I'll answer that question as I do 95% of the questions that I get on the podcast and here on YouTube down the rabbit hole under seal. That's where those phone records are. They are under seal. Yes, they've been talked about. Yes, there have been graphs, elaborate graphs that Judge Stephen J. Hippler developed in the order in limine on the motion regarding the text messages and the phone contacts. But hey, if he made those graphs, that means that those phone records and the messages were submitted to him. They're part of the court file. They can't say, oh, well, this is not part of the court file. You have to go to the Moscow Police Department to get that. It's part of Idaho versus Kohberger. For him to have been able to develop that graph that he did in the April 2025 in limine order on the text messages and the 911 call, why is that still under seal to the public? Can someone tell me why the actual text messages, for example, from one of the surviving roommates to the private driver who had allegedly, and we've been told, just had dropped off Kaylee and Madison minutes before at 2:10 a.m. Where's that text message? Why isn't the public allowed to see it? Okay, take out the phone number. We don't want to know the phone number. We want to see the timestamp and we want to see the contents of that message. Where's the message at 2:13 from the private driver? Right? Yes, I'm still driving. Didn't he say in his interview, which I believe is still online, that was released to the public, of the 14th of November 2022, that at 2:13 he was contacting someone to come pick him up somewhere else. He's communicating with someone within 1122, but he's also communicating with someone else at 2:13. This is why these records need to be released, because from what has been released, everything contradicts everything else. We can't tolerate this, in my opinion, of expecting someone else to tell us what the evidence is. We are all perfectly capable of reading the evidence, aren't we? To be able to come up with our own conclusions. And then what else do we have here? Thinking, has she withdrawn yet? Mamo is saying, I think it's a stall too. I think AT is off the case. Mamos, why do you think AT? Because she was sent a copy of, it was interesting. If you look at the copy of the court order yesterday, this is the amended order. Oh, don't even let me go down that rabbit hole. Oh, I will in a second. Just remind me to. Down the rabbit hole. Remind me to go down the rabbit hole regarding yesterday's court order. Yesterday's court order that was signed by Judge Stephen J. Hippler on January 5th, 2025 is on, or 2026, is on the amended order for the judge to reconsider releasing documents under seal. It was sent to two people and two people only by the clerk in Ada County. Those two people were William Thompson and Ann Taylor, and no one else. So interesting point that you're bringing up if AT is off the case, Mama, because she's still post closure of the criminal case. The case is still continuing because remember the matter regarding restitution, the court hearing that occurred in November, and then all of these documents under seal. At this rate, it's going to take Judge Hippler. I'm thinking, I thought initially 2 years. I got to reconfigure and say it's going to take 3 years at this rate for him to get through to the end of the case. There has been no motion for Ann Taylor to withdraw. There has been nothing of that effect as of yet in the current proceeding. And then so down the rabbit hole is Laughing. Valued member of my channel, thank you so much for your support. Okay, so she's reminding me. Yesterday's court order dealt with a motion, yet another motion under seal, 6 months after the Mr. Kohberger pled guilty plus. We don't know what that amended motion says. It is an order on an amended motion for the court to reconsider unsealing certain documents from this third court order that was filed almost 3 months ago, October 16th. They already raised their objections. You can read what their objections are. They were filed October 30th to the third court order. They then filed something asking for a hearing, asking for a decision without a hearing. And the only thing that was pending at the time had to do with this third court order. And then they filed a motion for reconsideration of whatever documents Judge Hippler had told. I guess he told both parties before anything was released to the public what was going to be unsealed, for them to come back and then file a motion asking him to reconsider. You see what I'm saying? They gave their objections. The state on the 30th of October, the defense, for whatever reasons, they filed their objections under seal on the 29th of October. For the state to come back and file a motion for reconsideration before the court ever rendered an order, there had to be some communication between the parties of what Judge Hippler was going to rule, right? So then we see the motion to reconsider. It was filed on the court docket on the 18th of December, 2025, before the December 18th, 2025 order that had all the rulings, including the important rulings on page 1 that said, okay, you had objections, denied, overruling. I'm releasing these documents without any redactions anyway. So it was the motion, and then came the order. Seems to me the court would have decided, hey, okay, I heard your objections, denied a second time, boom, here's my ruling. So that order yesterday is not to be thought of on its own. You got to go back to the docket, the months of October, November, and December, and see what was filed that preceded this order yesterday. Okay, so J-Rod is also, J-Rod, do you have questions that she may not be representing him? Oh, Carbon. There's few things I get fired up. The First Amendment and violations of it will do it. Like I said, I've been doing this podcast. I looked at not here on YouTube. My podcast is on Spotify. That's our home base. It was somewhere else. Then it got sold to Spotify. And then, I changed it from a general podcast talking about all things independent, which I love, books, music, culture, people. And then I decided to make it a true crime podcast. And the first, which I thought was going to be many cases that I was going to be covering, was Idaho versus Kohberger. And then when I saw the First Amendment implications, almost immediately, I said, okay, if I'm going to cover this case, I got to do it all in or not at all. And I said, First Amendment, under seal, gag order. Okay, it's going to be Idaho versus Kohberger and the First Amendment contemporaneously. We're up to, I think it's 900 episodes. And so 905 is our last episode on the podcast. And if you go back, there's got to be dozens upon dozens of past podcast episodes, which will be another order under seal. More evidence under seal from the public. Yet again, the parties have filed a stipulation to seal something or other. When is this gag order going to be rescinded? Oh, the media coalition has gone to the Idaho Supreme Court and tried to get the gag order set aside, as they did back in Latah County. Oh, they've come back again in January of 2025, the media coalition. Let's hope that they are successful and they are opposing this closed hearing on the day that all of the motions to suppress evidence were entertained by Judge Hippler. Remember that, the 23rd, 24th of January. It was the media coalition who came in and said, hey, we object. First Amendment. Here's why. We need to be there. We need to report back to the people regarding what's going on in your courtroom, Judge Hippler. And then they filed the July. They came back in July. They are the ones who got that gag order set aside. They filed a motion in July after he pled guilty, Mr. Kohberger, and said, okay, Mr. Kohberger has pled guilty. There's no reason to keep these documents under seal, and there's no reason to have a gag order. Well, there is a declaration which is evidence. This is testimony by a member of the media coalition, a reporter, graduate of the University of Idaho. Started working for the Lewiston Press, her first job out of college, which is not far from what I understand, Moscow. Then was promoted, and then she got a job with the Associated Press, global media outlet that's been around for decades. Then she got a supervisory position. She's been involved in preparing CLEs and CEUs for other journalists, involved with law school. I mean, she's got unbelievable credentials, 26 years of experience. She said, I've never seen a case sealed like this in my 26 years. I've been covering this case. Judge Hippler, be transparent, unseal the case, and here's why. And she went, you can read it. It's on the docket back in July 2025. Well, Judge Hippler said yes and no to the media. Judge Hippler said, okay, we'll lift the gag order, and that's the only reason why you started to see the state of Idaho. You started to see members of law enforcement give interviews as they did July 23rd, start to release certain select documents as the Moscow Police Department through the city of Moscow did July 23rd, and the Idaho State Police did. They've dropped 6 documents, batches, since that gag order was rescinded. But he said, nope, denied. They didn't even have a hearing on it. Denied, will not release the documents altogether. Got to go through each and every one of them. And then, beginning of August, he announced what the process would be. He said, look at a couple of months at a time, starting with July and June. We're going to work backwards. Those are the documents I am most familiar with. And gave them 2 weeks to give their objections or non-objections. So that was in August. 30 days after that ruling came down, he made a ruling 30 days later, and the documents that he ordered to be unsealed began popping up. But that didn't deal with evidence in a lot of ways, not like the in limine filings do. No way. That came out after 30 days. The second order, April and May of 2025, 36 days before the final order came out, where Hippler said, okay, these documents are going to still remain under seal, and here's why. These documents are going to be unredacted to the public, and here's why. These documents are going to be redacted, but still released to the public 36 days later. So we've got, what did Judge Hippler say at that hearing? Last hearing on the matter of restitution, when he was saying how, they said, well, Mr. Kohberger is destitute. He's in jail. He doesn't have earnings. How is he going to be able to pay this? Well, in the past, he got X number of dollars put into his account. So past behavior is indicative of future behavior. Past behavior where Judge Hippler is concerned means that a ruling should have come down within 30 or 36 days, right? Because that's the first and second order. This third order took 63 days from October 16th, when it was issued, to when we finally got the ruling on December 18th, but it wasn't even put on the docket on the 18th. We had to wait until the 19th to read that 18th ruling, because that's the day it hit the docket. So 63 days, that's the starting point. We're already dealing with about 2 months, 2 times longer than the prior 2 orders before Hippler rendered his ruling. Then it took another 12 days for a few of the documents to be unsealed. Then, boop, they got rescinded within a few hours. But that's not consistent with the court's order. The court's order said, hey, those documents were to be released with no redactions. I, for one, am very much looking forward to seeing how Judge Hippler rules on this amended motion for reconsideration, because I think he's got to give some sort of an explanation as to why he originally said these documents will be released with 0 redactions, and then they were pulled off the docket with no amending order. That December 18th order is still in effect as of today. Let's see what people are saying here. Yes, Mamo's thinking. Yes, that's exactly what I said. I said my fear was this case was going to then serve as a precedent, whether or not it's stated that way. The Kirk case is also being sealed to a large extent. CC, hey, thank you. Another one of our members. In my opinion, this was a buy for time. I feel there must be a way for them to appeal. Loopholes exist. I'm so happy, Carbon, another member of our channel. I've learned so much from you. Thank you so much. All I ask is that whoever you can, if you're having coffee with a friend and you want to talk and your friend's interested in true crime, bring up this case. Talk about what's going on in the First Amendment. Satire 777, good morning to you in chat. Speak with your elected officials. Send a letter to your elected officials. Let them know. Go to a public meeting if you can that deals with the first and express how you feel. Utah prosecution. She's wait. Okay. Christina's saying here, in her opinion, she's waiting for things to be unsealed before she appeals. You're talking about Ms. Taylor, Christina? And CC saying, I also think the defense knew the information would have to be released. And once the information is out there, it's available for them too, because state was 100% not handing over all discovery. But CC, that may be true. But let's go back in time 6 months ago. 6 months and what is it? 5 days? Change of plea hearing. Did Judge Hippler or Judge Hippler not ask Ann Taylor point blank after Mr. Kohberger pled guilty? He's got to go down his sheet to make sure that this was a knowing plea, that he hadn't been promised. Remember when he said all of those, that this is knowing, that nobody's promised you anything other than taking the DP off the table, and all the way down. Did he or did he not turn to Ann Taylor and say, Ms. Taylor, have you received all the discovery that you've needed? What did she respond? Did she say, no, Judge Hippler, I have not? She stood up as an officer of the court and said, yes, I did. I received all the discovery. For Mr. Kohberger here to now stand up before you, before everyone in this courtroom, and for the world to plead guilty. So that's the only issue that I seem to have with this. She didn't get her discovery. If that's, in my opinion, she should have said something at that time, but didn't. So J-Rod is saying, I question the plea deal due to victims' compensation was already set in stone. How come Hippler changed? Well, you know what? In Judge Hippler's defense, that restitution order could have been 3 or 4 times more because they also wanted travel expenses in there. And he said no. So what he ordered could have been a lot more. So that was the state's motion for restitution. The defense said it was a motion for additional restitution. So he really, although he granted it in part for the funeral expenses, he denied it in terms of travel. He denied all of that. So it was a partial state win and a partial defense win, in my humble opinion. Mamo's thinking, yes, she did, Mamo. She did. I mean, it wasn't a figment of my imagination, right? We got 71 people in here. Please, if you like our content, if you could hit the like button, it would really, really help. Really, really help us in the algorithm to get our First Amendment thought process and platform out in the community. Somebody say ineffective counsel. Richard, hi. So glad that you're here. Richard is also very much a proponent, I believe, of the First Amendment. That's grounds to seek an appeal. And ineffective counsel, also new evidence that comes to light that they didn't have before. R.J. Anderson, it might be. R.J. Anderson, what about deliberately hidden evidence? Example, the number plate camera clocked BK south of Moscow during the alleged time of the crime. You know, it's new evidence that wasn't known to the defense. It might be. We really need an Idaho attorney who could answer that question. An Idaho attorney would really be the person to ask. But in looking at at other cases, it just seems to say that if ineffective assistance of counsel, and also if you get new evidence. The problem here is that he pled guilty, so that can be used against him. But then he turns around and says, well, ineffective assistance of counsel plus, and again, we're just speaking, we've got no evidence that he is even thinking about. There is nothing, and we go by the documents. We go by what can be verified. Yes, there's a possibility he could, but from what I've seen no indication that he's displeased with Miss Taylor, because then we would see a motion possibly for permission for her to leave the case. That's not been filed on this court docket. There's nothing that's been filed in any appellate case that I'm aware of where he's appealing this case at all. So we're gonna continue to monitor the situation to see if we do see facts out there. Christina's saying maybe that's why she said yes. She said yeah on purpose so he could file his appeal. But then again, she's got a duty, Christina. She's got to show candor to the tribunal. She can't make false evidence to the tribunal. That could get her in a lot of trouble. And here's another thought. Do you guys remember this case was thought to be the trial of the decade, maybe of the new millennium of the century? What was the trial of the century that happened in the 1990s? Do you remember? RJ is also pointing out new evidence, fog lights off suspect vehicle. RJ is saying she had no choice to say yes. If she said no, there's no plea. But RJ, she had an obligation to be. I hear what you're saying, but she had an obligation to show candor to the tribunal. She needed to be truthful. And that because she could lose her license over that. Possibly, potentially. Again, just an opinion. Prosecution error on the record. Yes. Hey, I raised the issue if he was going to try to rescind his plea deal, because as you will recall, amongst other things, the state said it was a sentencing proceeding. Well, we had no, at one of them, it might have been the change of plea hearing. Well, we didn't have evidence to show that he intended to commit all the crimes. Well, why are you charging him with first degree? Capital punishment potentially. You need to show intent to commit the crime. And if you're saying that there was no intent, then that shouldn't have been first degree. So Nick is saying, I believe something is going on at the BK grounds. Ray would not have stayed quiet about. He might be, you know what? People may be quiet because of, remember what happened May 15th? There's also something else that's going on behind the scenes. Is a special prosecutor. It's been mentioned a few times, but there's been no update to the public. Remember the 2 court orders that Judge Hippler issued May 15th after his very terse words at the final pretrial conference regarding the Dateline situation. He said, I want the names of everybody who had access. And I want you to make sure that you tell them what it says in this order. Might be why we haven't heard from certain people. No one from the defense side said anything. Not the defense counsel. As far as I know, not any of the expert witnesses. It's all been from the state who have given press conferences beginning right after sentencing. Didn't the state, the Moscow Police Department, Detective Payne, the only time I recall him ever speaking publicly about this case, even though he was a lead detective, they gave a press conference, and then there's been other press conferences. Hey, gee whiz. OJ. Yes, OJ. Thank you for reminding me. OJ was indeed the trial of the century, or so they said. State of California versus OJ Simpson. The jury came back and adjudicated him not guilty. So he walked regarding and that was, again, it was, 2 unalivings. He walked. But what happened years later? He served time in prison for something that was related, but not that it had to do with the judgment that the families of Nicole and Ron had gotten, and that he was supposedly hiding some of his assets. He got caught in Las Vegas. He went to prison for years because of that. He didn't go to prison because of, he went to prison of the unalivings. He went to prison because he was adjudicated guilty following trial of hiding assets and of doing other things, of a battery in a hotel room and so forth. Here, do you think Judge Hippler could potentially get in trouble? Some of you have not been fans of Judge Hippler. Some of you have said, Judge Hippler should have granted the alternative perpetrator defense. I agree with that. I do agree. I felt that he stepped into the shoes of the jury when he made the ruling that the perpetrator or perpetrators did not walk to the scene of the crime. That was not his decision. That was a disputed fact, and that needed to go to the jury. I think that he should have been given more time to prep that alternative perpetrator defense. I also 100% even more strongly feel that trial should have been adjourned because of all of the incredulous pretrial publicity. Now, the motions to suppress, I think the defense made mistakes. I think the defense failed to show standing. You need to show standing. What standing does your client have to challenge IgG DNA? You had to argue that. She kept going to policies and procedures. Also, I don't understand why they rushed to get him back from Pennsylvania to Idaho, only to then spend so much time preparing all of those motions to strike the DP. Remember, those were the first motions that Judge Hippler entertained. They were all denied. He was in Pennsylvania, right? That's where he was arrested. He was arrested in the Commonwealth of Pennsylvania. If he would have opposed the sending of him back to Idaho from Pennsylvania, because remember, all of the states operate as their own mini governments. That's how this country was set up. Who would have had to sign the warrant? Who would have had to sign the order to forcibly send him back to Pennsylvania? The governor of Pennsylvania, who is a staunch anti-DP person and has been for decades. He served a position, I believe, as an attorney general for Pennsylvania, and he was very strongly opposed to the DP. He was elected governor. He was signed into office in January of 2023. The same month, Mr. Kohberger was appearing in a courtroom in Monroe County, Pennsylvania, and waiving extradition. That governor would have been the one to sign. Maybe there could have been some sort of an effort. Take the DP off the table, and I'll come back then. Like they do in so many other cases. When they escape to Mexico, if they escape to Canada, or certain countries in Europe that are staunchly anti-DP, the country will not return the person until there's an agreement that the DP will not be pursued. So I, for one, was very, very surprised to see the waiving of extradition that quickly and that easily, knowing that governor would have been the one to have to sign the paperwork to return him against his will without at least an effort to see if they could take the DP off the table. Others. Okay, judicial misconduct. Yeah, Richard, people have said, hey, they feel that Judge Hippler have gone as far as saying that he's another member of the prosecution. As I said, I don't necessarily agree with that. I've agreed with some of his rulings, especially and particularly. Imagine if the motion to suppress had to deal with the warrants. If some of those warrants could have been thrown out, then whatever was searched and seized per Fourth Amendment, that would have been fruit of the poisonous tree. But the defense did not argue standing. And even when Hippler stood there and said, Ms. Taylor, you're arguing policies and procedures, what the Supreme Court has said is not grounds to grant a motion to suppress. That is clear and unambiguous case law. She kept arguing policies and procedures. Yes, there's some question about the policies and procedures as it had to do. I don't disagree with that, but that was not the menu on the table for that day. But a lot of people feel that Judge Hippler was not fair, and he needed to be fair. 14th Amendment due process requires three things: notice of what the state is looking to take away from you, life, liberty, property, opportunity to be heard, and then finally, and most importantly, an impartial decision maker. That's a 14th Amendment requirement. And some people felt that was not here, that this was a biased juror. A lot of people feel that way. So now we have so they've lost all of these arguments. The defense did. What if one of the people whose social security numbers were disseminated to the world, or whose fingerprints were disseminated to the world at this time, when there's such an issue over identity theft, privacy, and so forth, what if they file complaints with whatever the body is that oversees judges? Because it is hard to sue a judge direct. I've seen people sue a judge. Very difficult to do because they have immunity, even when they act maliciously. They still have immunity. That's the law in the country right now. But another situation to possibly go to the governing board and allege judicial misconduct. Hey, he put out, in this case that's had so much publicity globally, my social security number is out there and it's toothpaste out of the tube. It doesn't matter that they talk it down because it's out there and people know it. And now I have to worry about identity theft. I have to worry about my safety and my security. What do you think? So Christina's saying that they were unalived outside and then brought in and staged. It's very difficult for me to listen to some of the audio that's been released from the 1112 camera, and some of the sounds that you hear on it. When compared, one of the content creators, Outcast, put all three together. He put the 1112 camera and audio. He put the Banfield body cam and audio. And he put the Linda Lane audio, and they're together so you can kind of hear it. This is why I'm really curious too about the text messages and 911, the 911 call and the calls from that went outside of 1122 from what we told into 1122 to the friends that were summoned, because we got one friend who was summoned who said the call to the apartment where he and HJ and EA and everybody else came in at 10 a.m. Isn't that what WSU Kim has been saying for years? They came in at 10 a.m. So Satire is saying she'd be filing suit regarding the release of personal information. If people get upset about that, I can't say I blame them. Why are you releasing? There's a section of that court order, Satire, it's section C, that says these documents will be unsealed, but with redactions to protect privacy interest. Protect privacy interest. And I don't know why he released them, but it's not someone who went rogue. It's not someone who wanted to undermine anyone. It's not someone in the clerk's office that wanted to leak information to the public. That was consistent with Judge Hippler's court order, Section A, December 18th, which again has not been amended as of today. Okay, and then we see, Jen 76 is saying this case set a horrible precedent. Rights matter, absolutely. This case is insane with the amount of violations. Everyone should be pissed. I agree with you. If we don't stand up for our rights and the rights of, our other citizens in the manner in which the founding documents to this country say, and for very good reasons, those 13 original colonies, 13 original states were brilliant when they said, we need a First Amendment here. We need to make sure that we have freedom of speech, which is expression, which is art, all of that we have freedom of religion, that we have freedom to assemble peacefully, that we have freedom to petition government for grievances, so that if the government's not acting in a way that we feel is proper, that we can go in a proper way, in a proper manner, to let government know that. That's the First Amendment. There's 5 freedoms in one there. And then you have one that's not really known, the Fourth Amendment. We can't be required to quarter soldiers. What the heck's that? Well, during the Revolutionary War, if a British soldier walked down the street, in some colonial town in Massachusetts or Rhode Island or Pennsylvania and said, I want to live in your house. I want your wife to cook for me, and you need to get out. They had to do it under the king who was running this country. They said, hey, we're not having any more of that. We're going to have that Fourth Amendment. Oh, look at satire. She's seeing things in a very interesting way. She's saying karma's coming back to bite ceiling Hippler in the rump. Colleen is saying 100%. Mamos is saying, I had to have a new name and social security number for ID theft. It is mortifying. It is. Mamos, once your social security number is out there, and then look at the addresses, phone numbers, fingerprints, handprints, not of people that are alive. All of that was released. It's out there. How do you get that back? So what Mamos is sharing is that apparently she was the victim of you got to go to the police, you got to file a report, you then have to, whatever credit cards that get opened in your name fraudulently because they have your social security number, you got to go to them. Meantime, your accounts could be completely divested. It could take years. There was a situation, true story. Law enforcement official, a city that I was living in, said his child, his newborn baby's identity was stolen. So this is a big problem. This is a big problem. It could come back to be very, very seriously defended by the people who were impacted. Down the rabbit hole to hell, living in the UK, I envy your First Amendment rights. They're very important down the rabbit hole to hell. Very, very important. I feel, could you imagine if we didn't? I think the UK has also freedom of speech. Like you can go out and have a conversation with someone if you don't like what the prime minister is doing. But yeah, that was something that the 13 original, it's not the framers of the Constitution. It is the 13 original colonies, aka states, because they were the ones that crossed the Delaware with General Washington, December 26th of, what was it, 1774, before the Revolutionary War was won. They had to cross the Delaware from Pennsylvania to New Jersey. They didn't have adequate clothing. Some didn't even have shoes. It was snowing. It was cold. They had no food. They lacked medical care. They are fighting the most elite military in the world at that time. And we can't lose respect to how strong that British Army was. And they still won. They still won. Carbon 7950 is asking, why was there a portion of Maddie's west bedroom wall was removed, yet we have not read anything in the documents? We can make an educated guess that it's because that's where some of the red DNA was, and so they wanted to pull it out to test it, possibly. Okay, I remember them carrying the piece of wall out. Yes, Christina. Yes, very much. How the force is not going to be clear about it. I don't know. That on point, Reek, and that's a point. I think it was Mr. Embry who pointed out that none other than the head of ISP Investigations for Crime Scene Processing filled out a document. I haven't seen it yet, but it had something about possibly a pew-pew. It was an early document. I haven't seen it yet, but that's what another content creator is reporting. Doesn't have it. Who's to say the trial is fair? A man chooses light over. I was pulled over, her plates, and arrested. Comment shown up on the phone, but not on the computer. We don't even know. I'm seeing your comments. I'm seeing your comments. Okay, Jen. Oh, down the rabbit hole. Okay, saying Jedrod, I saw the body cam of Snyder talking to Gunderson, and he states a pistol may have been used. They spoke outside 1122. Oh, I got to look at that body cam. Thank you so much, down the rabbit hole. I must have missed that. My focus on Officer Snyder, Corporal Snyder, and when you turn around, what do you see on his uniform? K9, right? He's the only one of the first five. All of the people from Moscow Police Department, whoever reported on the first, including those who came later. He's the only one who has canine, police canine on his uniform. Yet he was just back. He had just come from an 1133 call for a canine on a main street 1.2 miles away from 1122 King Road. He didn't have canine officer Ragnar with him. He didn't have his body cam with him. You think, if they're going to search your car, I don't know. We don't know what that 11:33 a.m. search, because there was no report written about it. But let's just say it was a search of a car. You don't think body cam is going to be on to catch every step of what canine Ragnar is sniffing and doing, in case the defendant decides to raise a Fourth Amendment violation, yet he turned up in a car other than his typical car, which says canine on it, and which is used to transport Officer Ragnar with him. He had no body cam on him. He turned up with the canine credentials, and then we see some photographs of something that looks like a substance that was broken down in one of the rooms in a baggie. Should the canine have been brought with him to kind of go through the property to see if not throwing shade on anybody, we don't know, but wouldn't that be something that you'd want to check off your list? Did this have something to do with rugs? And guess what canine Ragnar's specialty was? It was the poison that begins with F and ends with NYL that has been responsible for so much pain and grief in this country. There was another canine officer that came through later on. It was a dark, you might have seen him or her over by the fence with another. That certainly wasn't Snyder, and that wasn't Ragnar. Ragnar has a light coat. So why was MPD's own canine officer not allowed to come on with his partner? When they're on duty together. Does Idaho use privately owned and operated prisons? Is there some kids for cat? I don't know. Satire is raising a very, very interesting question. Now, this is one thing that you probably did not learn when you were possibly exposed to mass media reports relative to what was on Mr. Kohberger's past history of what he read or saw on his phone or his computer, such as adult material and other things. You probably didn't know that the only thing that he pulled down off of his Dropbox was the Kids for Cash documentary, which dealt with him. He's from Pennsylvania. There was a situation in Pennsylvania back in 2008 where a corrupt judge was prosecuted, and he was imprisoned for a number of years for sending children, most of them early teens, to these private detention centers, and he was getting kickbacks for it. So he and one of the executives from the center, and that's the Kids for Cash documentary, the only documentary that Mr. Kohberger ever pulled down onto his Dropbox account, that was from 2021. That was a warrant that Detective Mallory, in the Mallory documents that were approved to be released unredacted, showed. And I did a presentation, educational presentation about it a couple of days ago. It's a good documentary. It's very sad, and it is disturbing. It's also disturbing that the corrupt judge did not serve his entire term. He was pardoned, and people who were impacted were, to say they were upset is a understatement. I had someone who wrote to me and said, lived in Pennsylvania, knew of the situation. One of the students who was ripped from their families, was a wrestler, good student, did well in school, but he was sent to one of these detention facilities, and it basically impacted his life until he unalived himself. Carbon's saying that in the documents there was no reference to red DNA being on the west bedroom wall of the third floor bedroom. Good to know. Thank you for sharing that. Yes, RJ is coming up with the facts once again. The sound of a pew pew, I have to be careful of what we say on here on YouTube, was reported by a neighbor. Yes, that's right on the body cam. Wasn't it Gunderson who walked over there and spoke with one of the neighbors? It was a couple who reported that. I'll add this, RJ. Isn't that what Mrs. G said in an early interview, that she had received a call from a family member in Moscow who said that there was a mass pew and that Kaylee was a victim? And what about, let's add a third point. We have RJ's point on the table. We have the point regarding the early interview. And then we have a surviving roommate on the first floor who said, I heard a loud bang and light coming through my door. Sounds consistent with a possible matter that you've raised, RJ, I believe. Because think about where, first off, putting aside the loud bang that she said she heard, how does she see light coming into her door? Because let's just say the front door was bashed in. That front door apparently did not have a secure lock. A lot of people knew what the combination was. It had not been serviced for 2 years. We learned that from a batch of documents related to the investigation that the ISP dropped. It hadn't been serviced in 2 years. The code hadn't been changed. So the people and whoever else was renting the property the year and 2 years before and gave out that code to whoever they felt, they still had the current code. Still have the current code. So let me just take a sip, ladies and gentlemen. Give me 1 second. Need a little bit of water here. Okay, you know where, does everybody know where BF's bedroom was on the first floor, right? It is underneath the staircase, quite a ways. You got to open the door. You got to make that left. You go past the bathroom. You go past that utility room, and then you reach her bedroom door. How is she going to see a flash from the front door all the way, if it was coming from the second floor? How do you see a flash, hear a bang on the first floor when someone's on the second floor does not hear a flash or a bang? It seems to me that there was something happening on that first floor that would suggest what my opinion, and my opinion means nothing more than anyone else, but I believe that there was one perpetrator involved. I came to that conclusion after reading what the state of Idaho had said in documents that were released, the extent of the injuries and how much time it would have taken to inflict all, and then hearing that Kaylee was, I thought reading the affidavit of probable cause, I don't know about y'all, but I thought from reading the affidavit of probable cause, when it was said that Kaylee was playing with her dog and said, someone's here, to which Detective Payne interjected, oh, but that could have also been Lana correcting the witness, that all happened on the third floor. Is that what you guys felt? Is that what you felt when you read the affidavit of probable cause? That when DM said that she heard Kaylee playing with the dog, that then she heard Kaylee say something to the effect of there's someone here, that happened on the third floor. Now we come to find out that Kaylee was downstairs playing with the dog per the surviving roommate, and made that and then started to run upstairs. So if she's sleeping in Maddie's room, or she's in Maddie's room, what does she do? Does she get up from her sleep, go downstairs, play with Murphy, dance, whatever she was doing? I think even saying that they had music on, and then goes upstairs to find allegedly BK in the act. And what'd she do? Jump in the bed and not run away screaming? Or if she had been upstairs, see that whole situation, it's one document contradicts another. That's my big problem with the case. And that's why I feel this case needs to be unsealed completely, not with social security numbers, of course. Redact the names, redact the redact the personal information. No more of this releasing people's fingerprints, all of that, but redact the facts. Put the facts in the public record. Put a picture of that sheath on the bed as it was found, not by the first 5 responders, because all 5 of them, none of them in their reports of November 13th say word one about seeing a sheath. They all went into that room. Sometimes they went into it twice. Officer Snyder took a series of photographs, including multiple photographs, inside that tiny room where Maddie and Kaylee were found, as what the public was told. He got close up to the bed enough to see and to make comments regarding lividity. If you're that close and you don't see a sheath on the bed that close and say, oh my goodness, we missed this first time around. Sergeant Gunderson, look right here. Here's a sheath. Let me take 25 photos of this from all angles. Let me take it from above, from below, from the right to the left, from the door, from the window. Let me take it from every part. We don't see anything like that in the description to the videos. Carbon saying, and she said the light was in the hallway, so how does she see a flash, right? So in any event, there's just so much from Michael is, hi, Michael, so glad that you're here, is saying DM's story has a changing tone from one interview to the other, and the PCA, it's impossible to tell if any accounts given are true. I seem to think that words were put into her mouth. She never said anything about the time to say that he had bushy eyebrows would have been to Nunez. That was the first time that she spoke, from what we understand, to law enforcement about the events of 4:00 a.m. She never said a word. She said she couldn't see his eyes. She couldn't tell what the eye color was. How's she seeing his eyebrows? It was later on, after it was noted that, oh, she's got photographs in her room of eyebrows. And, a lot of girls, they like to take photographs, they like to put up posters of makeup, how you might shape your eyebrows, if you like lipstick or something like that. It was after that, then all of a sudden it came out. But she also said, hey, in her defense, after he was arrested, they went to her and said, is this the person that you saw in the house that night? She was given a copy of his, I guess it was his mugshot. She said no. Can you imagine how much pressure it would have been? How she would have been the toast of Idaho if she would have said yes. But she said, no, I can't make that call. I can't say that it was him. See, it's a problem. More than one person DM. Oh, okay. So Mama's also pointing out that more than one person DM mentions in one statement. How someone on the first floor, on the third floor, doing what they did on the third floor, then come down, and then apparently Xana confronted him or her on the steps, and then chase around that table, not trip over that table, not trip over that low step. There was no evidence that he was ever in the house before, right? So that weird step that's real low off the ground, wouldn't you have fallen over on that weapon? Going or coming, wouldn't you have tripped, but somehow knew to jump over that step? Really duplicate. She didn't remember what was real. Well, that's true too, Colleen. Every one of them, every one of the statements. Oh, I was drinking. I was this. We were heavily drinking, but you knew how to walk home. There's certain things that you remember. There's certain things you don't remember. And I'm sorry, those interviews were softball interviews. First and foremost, I think that any other law enforcement agency in the world would have separated all of the people that were standing outside of 1122, brought them downtown, put them in separate rooms. This way, they're not able to hear each other. And maybe they're not even wanting to do anything wrong, but someone else said that they're standing a foot away from might influence them, even on a subconscious level, of what to say. That's why you separate witnesses. They ask no follow-up questions. It was all softball type questions for the most part. And again, that's just my opinion. I want to say again, everything that I say here is opinion only. I don't know anything more than anyone else. I'm just going off the documents. I'm giving my opinion, pure speculation, pure rhetorical questions, and that's it. But it felt like there should have been more questions that were asked than were. Yeah, Colleen's saying that L did not know if HJ was really there all night. And didn't he live just right down the, I mean, weren't they staying in an apartment on Taylor Avenue, which HJ also lived in? During the plea hearing, why would Ann Taylor respond? Edward, I'm asking, I made that point many times. I made that point many times. During the plea hearing, why would Ann Taylor respond yes to Judge Hippler when he asked her if she had reviewed all the discovery? How could that hurt BK if he wanted to file PCR? Don't know. Don't know, but I have to raise that. If she didn't receive all the discovery but responded yes, that's a problem. That's a problem. Because she's got an ethical obligation to show candor to the tribunal. So in other words, if there was this intent from that point to, okay, we're going to plead guilty, but we're going to appeal we need time, we need whatever, and then we'll come back later. They're going to ask, well, why did you respond yes to a direct question from the court? You raise an interesting point. Does not know text messages would have typos. Oh, Richard's saying, hey, text messages when drunk would have typos. From personal experience, I might answer yes to that question. Also, Richard, that was to help him get ineffective counsel. Yeah, okay. What about post-conviction relief? Kathleen, there's no evidence right now that Mr. Kohberger is seeking any post-conviction relief. I was a little bit surprised that he didn't do it because the best time to have done that would have been the time that he entered his change of plea before final sentencing. And I was wondering, if you go back and look at my past content from July, I pointed out that, hey, you got the prosecutor here admitting that he didn't intend to unalive all of the victims. Well, you need to show intent, don't you, in order to raise first degree? Then maybe some of the charges should have been maybe 2 first degree and 2 second degree, or involuntary or something else. Certainly not first degree, but that didn't happen. License plate is unfounded. It came from a YouTube post with no receipt unless one's posted. Okay. Literally, the post hearing, she said she didn't go through it all. William Tardy is saying, yeah, hey, William, good to see you here. Member of our channel, I appreciate this. Edward is saying, I think he would be silly not to file one unless he had a come to Jesus moment with his team. Hard to understand. Edward, I keep going back. I'm like a broken record with this point. But it is until this case is unsealed such that we can see what the evidence was, not just only against him, but the evidence showing that he was the only one from soup to nuts responsible for the crimes. We're not going to know. And I don't understand this insistence to keep this case under seal this long. Said it before, unalivings happen every day in this country. Cases of other unalivings, even multiple, are not sealed like this. This case was effectively sealed from the minute Moscow Police Department started saying, well, we're not going to release a picture of suspect vehicle 1. We're going to release a picture of 2 stand-ins, including one with a sunroof. And you're just going to have to trust us that we've got this other video and photo. Seems like they had a lot of video of suspect vehicle 1 by the time that bolo was put out. First to neighboring law enforcement at the end of November, which resulted in the 2 calling in a tip same day within a half hour of each other. That was not 1, that was 2. That's going to get you double the attention, in my opinion. And then a week later, when it went out to the public, even if you look at the pressers from, I think it's either December 29th, the day that the affidavit of probable cause was signed, it's still saying we need the public's help in finding a 2013 to a 2015 Elantra. It was never changed. It was never changed to, and it could also be something else. And then what about, I just did a presentation based on one of the new documents that came out that tells us that law enforcement searched a car that was not an Elantra just a couple of days after. Why are you searching that car if you think it's a 2011 to a 13 Elantra? So many questions. I mean, what about this? Affidavit of probable cause says, page 1. What does page 1 say? See, it's not an affidavit, it's a declaration. There's no notary public sworn and subscribed to. That's an affidavit. It's a declaration of Detective Brett Payne, but he does say at the very end, everything here that comes before is true under penalty of perjury. Page 1, Detective Payne writes that at about 4 p.m., he, accompanied by Sergeant Blacker, both of the Moscow Police Department, arrived at 1122 King Road in order to help with scene security. And he says that, who was it that walked him through? Who remembers? He said that one of the first 5, and he calls him an initial responder. One of the first 5 said, yeah, I'll walk you through, Detective Payne or Corporal Payne. Wasn't it Corbin Smith? Same Corbin Smith who turned up at 1122 was told to guard that back door and kept going into the in and out of that kitchen. How many times? Right. They thought, Nunez said, you can hear it on body cam, we think the point of entry is the slider. It's open. He's walking in and out of that slider, and it's not open all the way. So could his heavy jacket might have rubbed against, stepped on, interfered, interrupted? We don't know. He's standing in the kitchen. Some people think that there might have been a portion of the crimes that occurred in the kitchen. Well, what are you doing? Walking back and forth in the kitchen so many times, meeting with this one, meeting with that one. Why aren't you standing outside? Even when his body cam shows him leaving, he walks through the house another time instead of just walking around to the front. And then the topper is when Captain Lanier turns up. When Captain Lanier turns up, walks him through yet again. They go through the house. And why is that an issue potentially? Because every time someone walks through that house, after they cleared it and they found that they had 4 unalive, every time someone else walks through that house, there's a potential of DNA being carried away on the person who's walking through, or they're dropping DNA. We drop DNA all the time. We don't know it. Hair, sweat, tears. You could touch some fingernail. They're using the same gloves. It's contaminating whatever they touched before onto another part of the property. That's why they tell you, and you can read, they tell you, you want to secure that crime scene and make sure that no one who needs to go through goes through. Well, we have Lanier walking through, and then when he leaves, he's walking right over the footprints in the snow in the back that Corbin Smith had very studiously taken photographs of. And you see it after he's taking photographs of those back snow prints. And there you have Lanier walking over those same prints. Now, I don't know if that's associated with the crime or not, but Corbin Smith certainly did because he took all of those photographs. And then ISP took photographs of those footprints in the snow in the back. They might have been taking footprints of Lanier's footprints. They might have been taking photographs, the ISP who processed the crime scene, of Captain Lanier's footprints in the back. Okay, let's go back to Corbin Smith and the affidavit of probable cause. Page one says right there, it was Corbin Smith who said, okay, detective, I'll walk you through, takes them through. They enter through the front door, go up the steps, make the turn. He notices that there's a bathroom on his left, and then he sees, in the bedroom, there's 2 people in there. Then they proceed to go upstairs, notes that he had looked at Nunez's body cam, that there was a dog. It's another question. Why was the dog removed? Did anyone check with the ISP to see if maybe that dog had DNA on him, on his paws, on his coat? No, they decide they're going to remove him. We'll get to that in a second. That's another rabbit hole down the rabbit hole, if you can remind me about later. All right, so then he says, okay, Corbin Smith then points to a door on the other side of the bathroom. Payne makes a notation that there's a door, there's a bathroom adjacent to the room where Kaylee and Maddie are found. And he says, later, I noticed there was a sheath visible from the doorway when seen on the right-hand side of Maddie. And then we have at 5 p.m. another walkthrough that happened. Payne, Blacker, the detective in charge of ISP, Thompson, and who's the assistant, his assistant, the other attorney for Latah County. The five of them walk through, and he says, oh, yeah, there's a sheath there on the left side of Maddie, visible from the door. Well, getting back to the first issue, Corbin Smith, you see him on body cam turning over his book to Warner, one of the other MPD officers, because he's now being relieved by Warner from his duty watching the back entry of the house. Walks through the house, goes down the steps. He's talking to the cop at the front door. Oh, my cruiser, where is it? Maybe somebody else took it. So it sounds like he's wanting to leave, maybe end of shift. Continue to think that it's end of shift because he started writing his report. It's the first report. First, yes, that's him, Richard. Yes, was Corbin Smith Bigfoot who planted his foot? No. Corbin Smith took the photographs of the footprints in the snow. It was Captain Lanier who walked over those footprints after Corbin Smith took him through the house. Corbin Smith writes his report very early. It is the first report that the city of Moscow released of all the documents that they released back on July 23rd. First report, Corbin Smith from November 13th. He wrote it contemporaneous. He's not one of these who wrote it like 6 weeks later. He wrote it that day, started writing it at approximately like 4:07, ended writing it at like 4:20. It's almost like the timeline of the crime, only 12 hours later, right? Wasn't the timeline of the crime approximately 4:07 to 4:20? He signs it. He talks about some of the other members of MPD who he interacted with, Gunderson, Warner, the other first responders. Not word one about Detective Payne, not word one of walking Detective Payne through. Then he signs it, and it's approved by whoever approved it, another member of MPD. Why are you writing a report if it's not your end of shift? Cops usually don't write a mid-report duty at one location and then come back and write a second report. That's the only one that's ever been released for Corbin Smith. He doesn't say a word about walking Payne through. Now, who walked? Yes, thank you. It was Ashley Jennings. Leslie is reminding me. So we've got that contradiction. Who walked? How many times did Payne go through? Why is he walking through after 4 if he's going to walk through again at 5 o'clock with the crew of 5? Including, yes, it was Ashley Jennings, it was Thompson, it was the detective who was the head of ISP, crime scene processing, Payne, Blacker. So why is he going through a second time? And why isn't it confirmed that it was Corbin Smith who walked him through the property? This is why it's so important to look at the documents. It's so important to look at the documents and read them because you're going to come up with all of these questions. Okay. Kaylee's is talking about Corbin Smith. The other two people. He's listed. I remembered him, Corbin, from the affidavit of probable cause because he's listed immediately. It's second paragraph, page 1. And then Payne continues to talk about Smith. The bottom page 1 into page 2, because page 1, he's on the first floor. He's walking upstairs. Smith is escorting him too. And then he's walking. Page 2 talks about going upstairs and the alleged discovery later. I think again, you have to kind of speculate. We don't know. I think maybe when he says later, it was discovered on the bed later. That might have been during the 5 o'clock walkthrough. But my question then is, why didn't everybody else who walked through sometimes more than once mention that sheath? That is and let's not even get into the 3 days in Moscow and what happened to that sheath before it ever went to ISP. Do we want to talk about that? And we do have 101 people here, but only 67 likes. So I guess that 34 people don't like me. If not, please, if you could hit the like button, it would really, really help me out a lot in trying to get our content out about the First Amendment in the universe out there. Do we want to talk about, I have to respectfully disagree with what's been said that they would have eventually gotten to Mr. Kohberger without that sheath. That sheath was the case. My humble opinion. Without that sheath. Without that sheath, whether or not you agree with the findings, you disagree with the findings, that sheath was the case. So, the story is, what is the story about the sheath? Who knows? Was the sheath taken to Meridian? They said, oh my gosh, we got 4 people unalived in the way that they have. And here's a sheath. USMC leather sheath on the bed with 2 of the victims. Who found it? We don't know. Was it found by ISP? As Sergeant Blacker said, Sergeant Blacker, in his report, when he addresses his taking of the DNA profile, not the sheath, but the DNA profile, to Othram, he says everything was sealed with evidence tape and it had initials on it. Remember that, because what we're going to talk about in just a second. But he also said that it was ISP who found the sheath. Now, if you listen to an interview that Anjanette Levy took of the chief of police, Anthony Dallinger, he credits and he applauds Detective Brett Payne for finding the sheath. So who found that sheath? Well, we know it wasn't any of the first responders because it's not noticed. It's not noted. It certainly doesn't appear to be. Officer Snyder, who walked up there with Gunderson by his side, went into Maddie's bedroom, took all those photographs. He doesn't mention one photo of a sheath. It didn't happen until later that day. But then what's more ambiguous about that sheath? Right, we're not sure. Leslie's saying we're not sure who found it, Payne or ISP. 100% agree with you. Thank you so much, J-Rod. My dear friend, please like, subscribe, and share content for a great creator like Kathy. I appreciate you so much. Thank you. You've been a long-term supporter of me. I appreciate it. Carbon, thank you for your kind words of support and being a member of the channel. Christina, thank you. I can't believe that anybody takes the time out of their busy. You got so much. You have limited time during your day. You have a lot of content out there on YouTube and anywhere else. And for anybody to read my content, to think it's valuable, to like it, to share it, to become a member, it's beyond, I'm beyond humbled. I want to thank you all for all of that and everything above. Okay. Let's go back to Carbon. Please remind me of that point later on regarding the wounds of what we heard initially, such as Kaylee was, didn't we hear that Kaylee was sitting up in the bed? She was in a sitting position at one point. And then the photograph that was released does not show her in a sitting position. It shows her lying down on her side, does it not? Okay, let's get to the sheath. I have a series that I call 3 Days in Moscow that talks about the sheath, concerns about the chain of custody regarding the sheath, concerns about the condition that the sheath was in, concerned about that the sheath wasn't immediately taken to ISP for testing immediately. So let's talk about what we know about the sheath. What do we know about the sheath? First time we heard about this sheath was where? We got to go back to the warrant affidavit. That's what it is. Detective Brett Payne, page number 2, after he says that he was walked through the property with Officer Smith. Officer Smith doesn't mention a word of it in his report. Said that standing from the door, he later noticed the sheath on the side, right side of Maddie. All right, so that's 4 o'clock. It either happened at 4 or it happened at 5. I'm of the opinion that that happened at 5, because right after that, we then saw, okay, ISP, they just got the warrant. They could start going through, because they got to start taking out evidence, and they can't take evidence out of a private property until they get a warrant. So Marshall signs. I think we see Nunez leaving the crime scene 11:22, heading back probably to the Moscow Police Department to write the warrant. That was then given to, it had to have been Magistrate Marshall who signed off on that warrant. Then ISP could go in and do their thing. What about when they're standing outside? What was it, at 4 o'clock or something, when Ashley Jennings comes in, and you just see her walking past everybody, going right into the property, and goes to, they say, where's the effect of Moscow? But you guys aren't walking in and out of there. And I thought to myself, boy, that question's about 4 hours too late, sir. You know, it's like, Take a look. I would love to see what ISP has to say about the dog being removed, the number of people that walked in and out of that crime scene, and the like. Then I'd like to know from the ISP's forensic department how much evidence they found that came from unknown sources, i.e., maybe the Moscow Police Department, from their in and out, back and forth, up and down, walking in, stepping over things. That's one question that I ask rhetorically. Okay, returning to the sheath one more time. The sheath was found, let's call it, okay, William Tardy's coming right out. He's calling the sheath as suspect. The sheath was found, let's say at 5:00 p.m. Right after that walk, the head of ISP crime processing started doling out the activities. Okay, you're going to throw down the yellow numbers, the markings. You're going to start taking photographs. You're going to do this. You're going to do that. So ISP did not start processing until 5:30 p.m. Yes, you may have seen them pull up one body cam at like 2:45 with that big truck, but they didn't go in. They had to wait for that warrant to go in. Warrant comes out. Walkthrough happens. 5:30 p.m. All of the assignments are doled out for what the ISP team's going to do. That process ended first day at approximately 12:10 the next morning. We know that from the documents that ISP had provided to us. What happens to, and he documented all the physical evidence that came out of the house on that first day. And that first day is November 13th, 2022. If you go down to like number 11 or 13, you're going to see USMC sheath, leather sheath. It's way down there. It's like, towards the middle, if not the end of the listing of physical evidence. What happened to all the physical evidence that was taken out of the house? Did it go to ISP for? No. ISP doesn't test. They were there. Their assignment was you process the crime scene. ISP tests what the referring agency who has jurisdiction tells them to test. You'll see that in all the documents that you've seen that shows what was submitted. You're going to see Sergeant Blacker's name on everything. You're going to see Detective Payne's name on nothing of the important testing of the evidence from the house. All of the evidence per documentation from ISP is given to, including the sheath, to Detective Payne. Okay? I'll say it again. All of the evidence that was recovered from the property that the ISP crime scene processing department felt was relevant and to the crimes was collected, and it was given to Detective Payne. What happened then? The Detective Payne say, oh, wait a second here. There's 20,000 people here from ISP. Thank you, Tracy. I'm glad you like our content. Thank you so much. We need one of you to take this sheath up to Meridian. Let me call and get the approval from my boss. Don't go anywhere, because we all know in law enforcement that if we don't have a suspect or a person of interest within 48 hours, the trail starts going cold. Now, by the time that they're standing there having this conversation, turning over the evidence, getting ready, ISP's getting ready to leave, it's like what, 24 hours, 21 hours after the start of the crimes at 4:00 a.m. We're talking this conversation happened 12:10 a.m. of the 14th. So now the perpetrator or perpetrators have been given a 20-hour lead on the cops? No, they didn't. They did nothing of the sort. Took the evidence, including the sheath, did whatever he did. I haven't seen I haven't seen anything that says chain of custody of the sheath that tells us the sheath was removed at such and then it was handed over to Detective Payne, and then Detective Payne did this, did that, and then the next person did this, and then they did this, and then did this, and then did this, all the way down to the 16th. The 16th of November, 2022. What happened then? A certain Walliford ISP law enforcement official is asked to come to MPD to pick up the sheath and take it to Meridian, which is several hours away. Take it to Meridian. for testing, but he doesn't drive it all the way to Meridian. He stops and he gives it to a Lieutenant Turrentine or something like that. We've done this. You can look it up and you can get 3 days in Moscow. It'll show you all the documentation, all the receipts. He takes it to ISP. So it eventually gets to ISP when late in the day on the 16th. And along the way, who is the woman who testified on the 23rd from ISP? Her name is, I'm drawing a blank. She was one of the ISP officials. She's a manager. It was Payne. It was her. And then there were a couple of other people from what the transcript tells us. Well, she proceeds to write a note. We got some problems with this documentation. The sheath is on its way. And she's already writing a note to file. Hey, team, we got a problem with the documentation. The person down at the Moscow Police Department in the evidence department is not in this week. So there's a person who's trying to fill her or his job. And you know, when you have a fill-in, they may or may not be trained as you were if you go out, right? So they're trying to give her assistance or him assistance from where they are in Meridian as to how to document this sheath, because Moscow Police Department had custody until the ISP picked it up on the 16th, the day before it was tested. So we know that already there's problems. And then take a look at what it says. Take a look at what it says. The ISP forensic department has a document. I've provided discussion points on it. You can look it up on the Indie Zone. We've got it, and we'll show it to you. That says, it's got Turrentine's name. It doesn't have Walliford in chain of custody. Turrentine is number one. They don't list that Walliford is the person who actually picked up the sheath. So right away, my mind's, going. But then it said that the sheath did not have evidence tape on it. It was in a brown bag. It didn't have evidence tape sealing it, and it didn't have anyone's initials sealing it. They had to do that in Meridian. So when you see that package with evidence tape and initials on it, that wasn't placed in Moscow. That happened. So that entire week, that sheath wasn't protected with evidence tape that it was in the hands of the Moscow Police Department, and it didn't have initials on it. So why wasn't there an in limine motion challenging chain of custody of the most important piece of evidence in the case? That's a question that I asked rhetorically, again, rhetorical question. And then, has anyone ever seen a picture of the sheath? No. We've never seen a picture of the sheath, not in Maddie's room, and we're not going to see it now because of the Laramie decision. I'd like to see a picture of the sheath when it was turned over from ISP to MPD. Was it in a bag? Did it have evidence tape around it? Or did it not? And then I want to see a picture of the sheath as it was in Moscow for those 3 days. We know that it didn't have evidence tape around it, and it didn't have initials on it. Where's the chain of custody showing all of these things? Okay, when you read the report for November 17th of the testing of the sheath, read what it says. It's like that's the way it was turned over to the scientist. I think it's Kathleen Wilt, whatever her name was. She's making like this is the way it was turned over from. It was not. And even then we have Sergeant Blacker who's going to back me up on this point, because his report from when he took the DNA profile to Othram says it was sealed properly with evidence tape and initials. I rest my case, ladies and gentlemen. I got to hear what you have to say. Was there? Okay, Kathy, prosecution was saying Kohberger's DNA was on the button. Yeah, that's another good point. J-Rod is raising the issue that DNA prosecution was saying, didn't we hear that over and over again, that Mr. Kohberger's DNA was on the button of the sheath? But in the report, they said that it was preserved for fingerprints, right? And it was like they tested an area on the underside that was not the button, but that was like right next to it. Raising a good point. See what else I'm telling you. It all comes back to the university. Kathleen is raising for one, Kathleen, I don't know why the university was so involved in the investigation. Number one, okay, I could see early on, you have to confirm that they were all students and all of that. They put out the alert, the vandal alert. But this property wasn't on campus. Now, had this happened at Sigma Chi, that's on campus. But the end of Banfield is where the end of the University of Idaho property line ends. Cross over Taylor, you're off campus. Walk a few steps more and you hit Queen Road, off campus. Why is he standing there, the president of the university, at every press conference? Hey, this just maybe me, but I would think that Detective Payne would be up there if he's the lead detective to give some reassurances to the community. No, what is he doing up there? And then we hear that he was in the war room with all of the members of law enforcement where they're going on strategy. Why is he, if that's true, why is he sitting in there? Why is he telling the students to go home? The students might have had important details. They might have heard something. They might know something that could help law enforcement. Why is he telling them to go home early? Thanksgiving wasn't for another week. And you see all the people leaving, including the people from 1112. The person who was supposed, and then we see the person who supposedly had called and said, you need me to come pick you up. I'll come. And then there's discrepancies with that whole scenario that we published just the other day. She wasn't in Moscow when LE spoke. They had to talk to her over the phone. That's a whole different scenario than having somebody in front of you on camera. You're taking the video and being able to watch body language and immediately doing it on the 13th, not days later. Richard is asking, maybe the sheath had been removed from the evidence bag by someone sketchy, then placed in a brown paper bag. We don't know. Hey, Richard, I'd like to see, as I've said, I'd like to see, hey, this doesn't violate Laramie, right? Show us photographs of that sheath from in the condition that it was. ISP had to have taken photographs of the sheath. All right, maybe some are in the bedroom and concerned about Laramie, but what did you do to preserve? We just did an episode where they admitted that they went into Mr. Kohberger's apartment and took some material evidence. It wasn't placed in a bag, and they toted it away without a bag protecting it. Did they just hand them the sheath and say, "Okay, here it is. Here's the sheath," and then it was put in a bag at Moscow Police Department? You're right. That raises such an interesting question, Richard. I guess once we see the evidence under seal, we'll be able to answer these questions, but not until then. Colleen is saying, I just saw a judge throw out 3 cases and release 3 people from jail because no PC, no probable cause was issued in 48 hours. Good question. RJ is saying there's no real chain of custody for the sheath that MPD bought. Oh, okay. The victims have no expectation of privacy in a public investigation. William, you are absolutely correct, but to go social security numbers and things like that. Well, Carbon, very interesting you say that, because what had happened was the day before there was a public records request that was going to be fulfilled. The officials from the city of Moscow contacted the Laramie's attorney and told him what was, I don't know, give them the heads up or whatever. Bam, the next day came the motion and the complaint for an injunction the next day. That wound up with Judge Marshall saying, no photographs of the two. We don't want photograph. We want to see the sheath. I want to see the sheath on the bed, visible from the door, on the right side or on the left side, because we have conflicting statements here. That's what I would like to see. I think that that's important. Okay, that's not even right. I'm wondering if we'll ever see evidence again. Leslie is saying she's wondering if we'll ever see evidence again. Wonder what they did with the vegan supplements, Colleen's asking. William Tardy is saying, very, very well taken. I am just referring to photos, evidence. I don't want to see social security numbers, right? We don't need that. What's that? That's not relevant to anything. We want to see the evidence. That's what the public has a right to see. to make sure and to see why it is that one person and one person only was ever charged with this crime. I really won't see the cutout of the wall in Maddie's room either. Well, it's interesting, Carbon, because if you, some of the photos, and this kind of goes against what Laramie stands for, because if you look at, there's like a warehouse, a garage or something that MPD kept talking about, the city room, something like that, where they kept evidence. Because remember, they keep the evidence. The Moscow Police Department is the agency with jurisdiction. These crimes happened in their home, in their town. It's not the ISP. In fact, the ISP last presentation I did last night says that when Wilt, who did the testing on the sheath, was doing testing from other physical evidence, or didn't do testing of red DNA found on a banister at 1122, she's saying this evidence is being maintained here for further testing, but everything else goes back to Moscow Police Department. They have a place that they call the city room. There's photos on the ISP's website that has been released for several months now. And you will see what they believe is suspect vehicle 1 completely torn apart. In that, it looks like a garage of some kind. They call it the city room. You see the mattresses that were taken out. You see the stains on those mattresses. They are standing up right next to suspect vehicle 1, allegedly. And then behind it, there's bags and bags and bags and bags of other things. So if ISP released something, and there's several photographs, there's at least 3 of them, 4 of them, with what appears to be victims of DNA on it, doesn't that suggest that the ISP is not bound by, because Laramie only compels Moscow Police Department? Everyone's saying here that they don't want to see they don't want to see, they want to see the evidence. They want to see the evidence that's been withheld for 3 years now, right? 3 years now. We had the arrest happened on, the warrant of the affidavit of probable cause, the warrant, the complaint, the order of probable cause, that is December 29th. That's the official start of the case, 2022. The arrest happened the next day across the country in Pennsylvania, 12/30 of 22, December 30th. And then came the stipulation for the gag order between the two. This is why I keep saying it is not just the state that has wanted the public to not see this evidence. It is the defense as well. In fact, it was Ms. Taylor who came up with the first gag order language, presented it. They did it together, Thompson and Taylor, to Judge Marshall. She signed that order day 4 of the case. There was a gag order in place, plus all the documents and evidence under seal for more than 2.5 years. Case closed against Mr. Kohberger July 23rd. Here we are. It's more than a half year later, and this case is still largely under seal. Just a few documents from April and May, June and July of 2025 have been released to the public as of today. How long is it going to take for this process to be completed? Okay, I want to see. Okay, everybody's saying the same thing. People want to see Cyray's opinion and evidence. AT didn't seem to help to bring truths to light, is what Leslie. I also found it quite interesting that Leslie, I got to point this out. It was Ms. Massoff who wrote a motion and memorandum of law saying that the First Amendment required that hearing of the 23rd. They wanted the hearing open to the public when Brett Payne would be on the stand at the motions. It was the motion to suppress hearing, and also the Franks hearing. Even though, Hippler wound up denying everything, they turn around and say, oh, the public has a First Amendment right to see things. And it's like, oh, really? You finally figured that out? What about the 20,000 motions that you filed to seal evidence and documents from the case, or stipulations that was entered into the case, or the gag order that you drafted, or your team, Ms. Massoff didn't, it was Ms. Taylor. So you were finally realizing that there's something called the First Amendment right at the top of the Bill of Rights. That seems to say to me that the First Amendment coming first was the most important to the states. We're finally going to realize when it comes time to what you want to be released to the public that should be. I wrote about that. I said that was very hypocritical on the defense's part. Yes, I'd like to know that. Who leaked over the exaggerated crime scene descriptions to Patterson and Blum? Good question. Drastic change. It was. It was, Colleen. Yes. Okay. I think we're all on the same page here. We're all wanting, as members of the public, to see the evidence. Want to see the evidence on the record, right? Ooh, Sydney's coming up with a really interesting point. I have a bad feeling that Cy Ray was a Trojan horse for the prosecution. We're going to find out, hopefully, because the in limine filings have all of the under seal stuff that Judge Hippler, I don't know if he's going to come out and amend his order of December 18th. He might. He might. And then decide not to release the evidence that he said was going to be released to the public. And it's not even the stuff that was released for a few hours on the 30th. I'm talking about the in limine filings. And I'm talking about also the fourth order that still has not been issued for the end of 2024, because that's when all the motions to suppress came into play. That's when the motion for the Franks hearing came into play. And then we get to see everything that's been under seal that the defense is pointing to that felt that the warrant should have been thrown out, that searches and seizures should have been suppressed. Judge Hippler still has not rendered that fourth order as of yet. Okay. All right, guys, we've been going on for a very, very 2 hours. I have never done a live this long before in my life. So we went over a lot of really interesting things as things continue to unfold in the case. We're going to continue to wait to see what's going to happen on this order that Judge Hippler rendered yesterday regarding the states not being happy about what Judge Hippler apparently said ruled would be released to the public. We're going to wait and see. We're going to see if there's any explanation as to why things were deemed to be released without redactions on the 18th of December, were released for a few hours without redactions, exactly as that court order said, and then were pulled with no explanation to the public. We're going to look for the fourth court order taking us finally into the end of December of 2024, end of the year. We're going to look for the documents currently under seal from January, February, and March, including the critical, the crucial. I cannot stress how important it is, because this is the evidence in support of the in limine filings that Judge Hippler said, hey, he was going to release to the public. If there's any change in that court order, I'm going to go through it word by word, and you're going to know every word that changes. Charm Free, thank you so much. Thanks for being a member of the channel. Christina, thank you for being a member of the channel. I want to thank 8 more likes. Thank you, everyone. Please, please, please hit a like if you can. If you don't like me, don't hit it. If you do like me, please hit it. Okay, Carbon saying, I'm loving it, Kathy. It was our epiphany gift from you. Not wise men, but from wise. Oh, my gosh, you're too kind. Thank you, Carbon. I really appreciate it. Betty Blue, my pleasure. Everyone else, I want to thank you very much for being here today. Please look at our new content that we just put up if you haven't had an opportunity from last night and today. Look at the court order. It's up on the community page. It tells you, it gives you 6 examples of what was released on the 30th that is consistent with what Judge Hippler said was to be released. And things are continuing to be developed. If there's any word that there's an appeal, you're going to hear it first. We're going to continue to keep our eye on it. We're going to continue to keep an eye on this alleged lawsuit against WSU that mainstream media broke like 2 months ago that hasn't been filed. We're going to keep you posted about the Idaho for defamation case. That is the only case that has been filed in a civil context for money damages. It's been proceeding for 3 years now. It is going to trial next month. We're going to keep you posted on this, the Rob Reiner case. We're covering that. We're going to keep you posted on the appeal in the Delphi case. We're covering that. And we're going to keep you posted on State versus Wandra. Oh, I almost forgot to mention State versus Wandra. Very tragic case. It's the other case that if you go onto the Idaho Cases of Judicial Interest website, you're going to see 2 district court cases. The first one is State versus Wandra. The second is State versus Kohberger. State versus Wandra deals with a tragic, horrible case from 2017, where a 5-year-old went missing. It's a hard case to report on. It's a hard case to consider. Mr. Wandra was arrested this year. and the affidavit of probable cause is on the court docket. We've started covering this case. He was supposed to have his preliminary hearing in December. It got adjourned to March. Now, with Wandra, he signed a plea deal for something unrelated for what he's on trial. He's been arrested for now. Something unrelated. He signed a plea deal. He then had second thoughts after he signed it. He tried to get it set aside. He got appellate counsel from Idaho, public defender, to represent him. And then there was a ruling this was in federal court, as to what needs to be shown if you appeal something where you've signed a plea deal. Sound familiar? Sound familiar? That might be a case that I recommend, if you're interested in true crime, please take a look at it. Down the rabbit hole, what is saying here, Kathy, is Betty Blue states, Jules is having a conversation with the district attorney soon. Could you help her with what to ask, please? I love Jules. She hasn't asked for any of my help. I'd be happy to, if you could. Oh my, thank you for the subscription. I love you all. Okay, guys. I want to thank you all for being here today. I want to thank you all for supporting having the truth come out, so that our Constitution, as amended by the Bill of Rights, as demanded by the 13 original colonies / states, the heroes who won our independence and who got this country's founding documents amended to include the first 10 amendments, and then later the 14th Amendment, extremely important, the Due Process Clause. Thank you for following us. Share our content. Go ahead. I don't even care if you just share the content, get it out there, that the issues here don't just deal with the victims and Mr. Kohberger, as important that they are. There's a bigger, monumentally important issue, in my personal opinion, just mine, that I think is at issue here. So I want to thank you all. Have a great lunch, Blueberry. So glad that you were able to make you here. I'm so glad that you were here for even just a few minutes. We'll have the replay up if you'd like to replay it again. Please be sure to comment. Keep the conversation going. The content that we put out is intended to induce your conversation. Your opinions are very important. Everyone who is a member of this channel, who comments on this channel, could have very easily been on that jury back in August, could have been selected. Everyday people who are smart enough to understand what the documents say or don't say, but need the evidence unsealed to be able to have conversations and be able to do what they're supposed to do under the First Amendment to ensure that there's no abuses of power going on here. So with that said, thank you all. I'm glad that you were here today. We'll do another one soon. Until next time, ladies and gentlemen, this is Kathy. Thank you so much for joining us here today.